in a very beautiful city, the city of Baku, of course. We have not yet established formal cooperation ties with other universities, but we are on a very close personal contact basis with you two. But I also visited last time I was in Baku, your vice-president was, who we talked to, and I think we will certainly discuss future cooperation with a very interesting partner. In a partner university that has, to a certain extent, at least a special focus on international relations, international law in a broader sense. And that is the reason why we have such a highly interesting topic from international law perspective, illegal economic activities in the occupied territories. Thanks for coming. Professor Lev will give a short introduction on the person who is speaking, and then we continue.
Thank you very much. Thank you, Professor Titi. So, welcome. Also on behalf of myself, I am very glad to welcome here the delegation of the other university, the dean of the faculty, the joint faculty. It's political science, it's like internal affairs and international. Public policy and international affairs, and they have also a law faculty seat, or let's say law element have the still within this faculty, and the dean is just arriving from Leipzig from the airport, is on the way to us, he will join us later on. And today we have this very interesting and exciting topic on illegal economic activities in the occupied territories, which is actually, let's say, classic international, public international law topic, and I'm very happy that we could invite, and Farid Ahmadov, Dr. Farid Ahmadov had time. Actually, we used to study at the same time at the Baku State University. I was in the law faculty, and Farid was at the international law faculty at that time. Then we have, let's say, we have very different paths in our lives, two different paths. Farid has invitation from the University of Hamburg, but has made his choice for the University of Oxford, and has made his PhD there. Then, but he has, I don't know how could he do that. Today he has said that he goes in bed at 4 a.m. every day. And therefore he is also the vice president of the port of Baku, which is huge port, economic, very important issue. Is adjunct professor at the other university, and also dealing with anti-doping issues. He is in the anti-doping commission of Azerbaijan, which is quasi-judicial authority. And again, he's doing a lot of different. Okay, now we welcome our dean colleague from the other university. And we are very happy to have you here, Farid. The floor is yours.
Thank you very much.
Please go ahead.
Thank you very much indeed for the kind words, for the introduction, and for the invitation, Professor Titi. Dear colleagues, ladies and gentlemen, I have to make perhaps few notes regarding going to bed at 4 o'clock. Now that is in line with the number of children I have. So I have 4 children, so I go to bed at 4 o'clock. So that's very natural. If one of you gets to that point, be sure that's what's going to happen with you. Now, as far as I'm certainly very privileged to be addressing this distinguished audience. But not only am I privileged, I also feel trusted. Now the reason for that is when I first saw the title of the lecture series, which is Law After Lunch, it reminded me of contracts where parties agree on advance payment without a bank guarantee. Now here, if it was law before lunch, where you would ensure that, depending on the quality of presentation, you would decide whether he deserves lunch or not. Now here I am, and here you are, that would have to rely on my integrity, and I will have to consolidate my integrity to act in good faith against the advance payment of yours in the form of lunch. Now, speaking of the title of the presentation per se, now I have to make a caveat about it, and the vagueness, there is some vagueness in the title, and the blame for it is to be put on me. It might create the presumption that I will be talking about illegal activities per se. Now, obviously, and therefore, given the title, illegal economic activities in the occupied territories, there is a presumption, it misleads you into thinking that all activities in occupied territories are illegal, and I will be speaking about illegal activities per se. But rather, the purpose is to determine whether activities, economic activities in occupied territories, potentially this can be illegal activities under international law or illegal activities under domestic law. Now, given my background, obviously, my purpose is to look at, and given my background, again, I will be looking at illegality under international law, but given some vagueness relating to the scope of the obligations relating to this under international law, resort to state practice is inevitable. So, but this will be snapshots of state practice, obviously reference to the various countries, many different countries is difficult because I'm not well versed in the jurisdiction of various countries, but I will be looking I will look into some EU practice, but also into practice of what I call elite crowd, holy trinity of countries, Georgia, Azerbaijan, and the Ukraine, which have been lucky to be occupied, have occupied territories with sometimes with assistance of a third country, but I will not mention the country. Now, so when we are to talk about illegality per se, illegality under international law, the key question is under what rule of international law would certain activities be considered as illegal? Now the first, if we are to look into the case law, if we are to look into the articles on state responsibility, the first two obligations that come to one's mind, this is the obligation of non-recognition of the lawful, of the situation, the situation arising from a serious breach of the obligations arising from peremptory norms of international law, and the obligation on states not to render aid and assistance to maintain that situation. Now, this is classic Article 41 of the Articles on State Responsibility, which imposes this obligation on states. And there is a separate article in Articles on State Responsibility, which is Article 16, that deals with the separately, independently, with the obligation not to render aid and assistance to maintain the unlawful situation. Now, the discourse, the case law, if we are to look at the case law to understand the scope of the obligation of non-recognition, we will see that there is two elements of it. One element that is a formal element, it's a prohibition of formal non-recognition, that you will not recognize a particular situation as lawful, and this is a formal recognition. Now, but the obligation per se is not limited to this, and if we are to go to the case law of the International Court of Justice, and in particular the first case that is the known case to everyone, the Namibia advisory opinion, the Southwest Africa, and this is perhaps the only German colony, if my memory serves well, the Southwest Africa, maybe not. But in the Southwest Africa case, which concerned the legality of consequences of continued presence of South Africa in Namibia, which then was Southwest Africa, notwithstanding the Security Council resolution, you will find the court referring in various paragraphs, making references to the obligation, to the duty of non-recognition. Now, it certainly says in paragraph 119 that the states will not provide aid and assistance. But then in paragraph 124, you will see the court making a reference, making a statement where it qualifies it. It basically, in a way, defines the operational content of the obligation of the duty of non-recognition, and that is, it says that states shall refrain from dealings, acts, or any other form of relations with which would entrench the authority of South Africa in the territory in Southwest Africa. Then, in its operative clause 2 of the opinion, the court proceeds and makes another statement that states shall refrain from any dealings, any acts, any form, any relations with South Africa that would imply recognition. That would imply recognition of its presence. Now, if we are to interpret these provisions, if we are to look into these provisions, we will see that, in fact, there is no absolute prohibition. Absolute prohibition on activities in occupied territories, because it says, the court makes a qualification. It's the acts and dealings that would entrench the authority. It's the acts and dealings that would imply recognition, meaning that those acts that do not imply recognition and those acts that do not entrench the authority, they're not prohibited. Now, this certainly leaves us with a question: what acts would imply recognition and what acts would entrench the authority? Now, this certainly about this again takes us to the operational content of the obligation of non-recognition. The court does give some guidance relating this, and we know from the practice of case law, even from some domestic cases, in the context of by some UK courts, even in there is a reference to a certain extent in the Karlsruhe-Stiftung case, you will find that the court comes up with the idea of private rights exception. Now, James Crawford, in his report on the illegal activities in the occupied territories with respect to Palestine and Israel, says that minor administrative acts, such as birth certificates, death certificates, marriage certificates, or minor commercial acts of minor character, that is simply selling things that would be necessary, absolutely necessary to maintain, to ensure that those who are inhabitants of the occupied territory, they simply can survive. They can live their lives. Obviously, the marriage certificate is simply a statement of fact, or a death certificate, it's a confirmation of fact. If the person has died, he has died. There is nothing you can do about it, and there is a document that confirms it. Now, the documents of this kind, the acts of this kind are said not to amount to a violation of the duty of non-recognition. Now, obviously, as I noted, entering into treaty relations, for instance, with occupying power with respect to occupied territory would be a breach of an obligation of formal non-recognition. This is an act of a formal character, obviously that which is of a different kind. Now, if you look further into the content of the obligation, and the content of this obligation is to be again determined by recourse to the state practice or practice of other institutions, and maybe EU and the practice of some other states. Now, when I looked at the practice of EU, and again, to make a caveat here too, I'm not a biggest expert on EU law, but for the purposes of this presentation, I did look into the practice of EU with respect to various occupied territories. Now, and what I found, that EU has an ambivalent practice, and I would say fairly inconsistent practice with respect to various occupied territories. For instance, if you take EC guidelines on giving grants, and this is a very long title of the guideline, on giving grants, prizes, and financial instruments to the for the activities and entities established in Israel and operating in Palestine, then you will see that the guidelines prohibit giving those prizes, grants, and financial instruments to private entities, NGOs, even and local government authorities, the local authorities in Israel that are the entities that are established in Israel, but that are established in Israel, but who are performing activities beyond the 1967 boundary. So if you are to perform activities beyond the 1967 boundary, the EC guidelines prohibit giving grants, prizes, or financial instruments to those entities. However, the same guideline allows for grants, financial instruments, prizes to be given to central authorities of Israel for the purposes of activities in the occupied territories beyond 1967 boundary. So within one guideline, and I don't know what is the reason for that, you have difference in approaches with respect to funding and funding for different activities within the occupied territories. Now, if you further look into practice, for instance, EU practice regarding Northern Cyprus, which to me is an occupied territory, no matter how one stretches his imagination, that's an occupied territory. With respect to that occupied territory, you will find that many EU companies operating in Northern Cyprus, and in fact there is extensive university-to-university cooperation. Public universities engage in cooperation with universities established in Northern Cyprus. The only, perhaps, approach, the only restriction, perhaps there are other restrictions, but one restriction that comes to my mind is the issuance of certificates of origin. Now, ECJ in the Queen versus Minister of Agriculture case notes that Turkey cannot issue certificates of origin for products originating from Northern Cyprus. This is Cyprus that has to give those certificates of origin. Now, if you look again at the practice of EU with respect to Nagorno-Karabakh, the occupation of Nagorno-Karabakh and the territories in its vicinity, the other provinces in its vicinity, which interestingly, perhaps one of the questions to be asked is, what is the standard to apply to determine whether the territory is occupied or not? Because that's the key question. Now, how would you determine that? Based on what would you determine that? Is it the discretionary authority of the institution of the state to determine that? Or should we rely on someone else's, on a more objective authority? Now, with respect to Nagorno-Karabakh, I don't think there is too much a debate because the European Court on Human Rights in the Cheragov versus Armenia case has established very clearly that Armenia exercises effective control over the territories in Azerbaijan, and this is what we call occupied territories, and that it has to comply with obligations under international humanitarian law. So this is with respect to Armenia, not the Nagorno-Karabakh per se. But if you look into EU practice with respect to Nagorno-Karabakh, for instance, or even occupation of Georgia, yes, there are some measures taken, but if we are to compare it with EU practice with respect to Crimea and Sevastopol, we will see the standard is completely different. Now, I have in front of me Council Regulation number 692, 2004, June 23. This is concerning restrictive measures in response to illegal annexation of Crimea and Sevastopol. Council Decision 386. Then we have regulations, Council Regulations of 30 July 825. Then we have Council Regulation of 18 December, amending regulation. And if you look at these regulations, they do impose very serious restrictions on private actors, almost with respect to anything. It's an exhaustive list of activities. You have a long list of activities attached to these guidelines, where EU's position that you will not do this, private entities will not do this. This, with respect to, and this applies to private entities too, as I noted. Certainly to public entities. There is no question about it. Now, this is as far as this is a snapshot of EU's practice. But if you look, and this is to the extent my expertise allowed me, if you look at the practice of individual states within EU, and I looked into the practice of Ireland for this matter, you will see that Ireland has introduced a bill in 2018 where it criminalizes activities in occupied territories with respect to Palestine. Okay, this is a very narrow, specific practice with respect to Palestine, and the punishment is fairly severe. Yes, there are of punitory kind, but it's also up to 5 years of imprisonment, actually. So it's a very serious punishment that Ireland is proposing to envision. They've received two opinions on this from independent experts, and they all found that this is to be in compliance with international law. Now, interestingly, and this is for the purposes of establishing opinio juris, perhaps, because now EU has taken certain actions. Now we will have to understand, did EU feel compelled under international law to do this? Maybe under Article 21 of the treaty on functioning, because it has to comply with the principles of the UN Charter and international law. Okay? So, or whether it felt compelled to do it, or whether it looks at it as a matter of sanctions, of discretionary kind. It's a sanctions regime which it can apply, depending on the political considerations. It will apply it in one case and not apply in the other case. Now, if you look at the bill proposed by Ireland, you will see that Ireland does it, and it says the objectives of this law, of this bill, is to comply with Geneva Convention, number 4, with 4th Geneva Convention, and customary international humanitarian law. So in the law itself, it makes a declaration as to how it perceives the obligation under international law, and it says that we feel compelled under customary international law and 4th Geneva Convention to do it. So this is an element demonstrating opinio juris, that they feel compelled to do it, or at least that's their feeling, the psychological belief that we, what we call a psychological belief. Now, if you look, however, and this is obviously, there is a whole range of provisions in the Hague regulations, in the Geneva Conventions, as far as the, for instance, activities are concerned. Now, the Hague regulation does not prohibit, absolutely prohibit. Now, if you look at Article 55 of the Hague regulations, in fact, the occupying power can, in its capacity as a usufructuary, can exploit the resources. Now, can use the resources. But obviously, usufructuary to me means that you have to have a useful use of, not a wasteful use of something. So, and it has to be exclusively for the benefit of the population, as opposed to, as is the case, for instance, even in Crimea, Sevastopol, businesses that are operating there, they are paying taxes to Russia. The businesses that are operating in Nagorno-Karabakh and occupied territories, they are paying their taxes to Armenia. They get their licenses from Armenia and perform their functions in the occupied territories. Now, their activities are of extractive character. They engage in exploitation. They extract to the extent of depleting the resources. Which is strictly prohibited by the Hague, and which is against the idea of being a usufructuary of something. Because the very purpose is to deplete it rather than use it for the benefit of the population, and given that most of the population, for instance, in the case of Armenia, has been forced out anyway, there's only a small number of people that is left. So the argument that I'm using it for the purposes of the population rather than for my own benefit as an occupying power is that argument is slightly ticklish to me, at least, to put it in mild terms. Now, there is some other practice. There's a practice of Georgia, there's a practice of Ukraine, and by practice I refer to the laws of Georgia, the law of Georgia on occupied territories, and law of Ukraine of 2004 on securing the rights and freedoms of citizens and the legal regime in the temporarily occupied territory of Ukraine. Now these laws impose almost absolute restrictions, and they are penalizing eventually by reference in other laws in criminal legislation, which these laws make reference to. They are penalizing activities without the consent of central authorities, which is of Georgia and of Ukraine respectively. Now with respect to Azerbaijan, I have a problem with practice of Azerbaijan because we don't have a separate law on occupied territories. We only have provision in the criminal and administrative code that relate to illegal, unlawful entrepreneurial activities, but this applies to everyone. So whether you are in occupied territory or you are not in occupied territory, this applies to everyone. So there is no specific in the form of legislation, in the form of lex specialis that would apply to a particular region. Now, what distinguishes, and this is for the purpose of establishing customary international law, what distinguishes, for instance, a law of Ukraine, a law of Georgia, the council regulations, and the bill proposed by Ireland, is that in none of these laws, in the law of Georgia and law of Ukraine, you could get a sense of the country feeling that it's acting upon an obligation to legislate, to criminalize. It's simply criminalizing it. Now, in the bill, Irish bill, the objectives are very clearly stated. Now, in these laws, they're not clearly stated, and what puts a question mark under their perception of how they have to act, whether this is binding under international law to do it or not, is that they apply it to activities within the territory of Georgia by whatever the persons, but they do not criminalize or prohibit in any other way activities of Georgian persons, of Ukrainian persons, who would engage in activities in other occupied territories elsewhere. For what if Georgian national, Georgian person goes and engages in economic activities or whatever the activities in any other territory abroad? Now you have criminalized it, you have prohibited, so it seems like your attitude towards legality of it under international law only applies to your own occupied territory rather than to occupied territories elsewhere. Now, this is slightly ticklish to me with respect to formation of a customary obligation under international law that would impose a prohibition on this. Now, obviously, this is much of this could be an ambitious statement because a criticism of mine would be that you are jumping into conclusions based on a very limited analysis of state practice. Now, that is certainly for me, this was a challenge again, both linguistic challenge and obviously the challenge as far as my expertise is concerned to look into the practice of other states. But obviously, if we are to think of a positive obligations of states, a further research to establish a positive obligation of states to prohibit this activity under international law, further study of state practice will be required. And for instance, for a country like Azerbaijan, again, which is under occupation, the lack of domestic legislation is also telling, at least as far as our perception of whether this is illegal or legal under customary international law or not. Now, a positive obligation could be perhaps squeezed out, but subject to disagreement in the scholarly opinion, from Common Article 1 of the Geneva Conventions, which says that states, parties will respect and ensure respect. So ensuring respect, the term has been interpreted in many different ways, that it applies to the obligation of states to ensure that others also respect. Now, Does it extend as far as, for instance, or is it limited only to the occupying power? The obligation of the occupying power to respect itself, but also ensure respect that within the occupied territories others do not engage in illegal activities? Or does it apply to every other country, no matter where the occupation takes place, to make it criminal under domestic legislation to comply with provisions of the, because this is a grave breach. I mean, there are references, for instance, you could, by reference to the grave breaches under the Geneva Conventions, which is forced settlements, for instance, are considered to be grave breaches. And if you have private parties, private actors engaged in this process, one could say that this needs to be criminalized domestically. And as far as my memory serves, for instance, Australia has criminalized this, the grave breaches domestically, and applies it in the context of complicity in criminal acts, the private actors' complicity in criminal acts. Now, we certainly have states' direct involvement, but we have other actors in place too. Now, states do not necessarily act via their organs. In the occupied territories, you have a different blend of actors taking part. You have joint ventures between states and private entities. You have private entities acting independently. You have states acting on their own through their agencies, through their organs. Now, when we are talking about the state organ, okay, the obligations directly apply to states, we have no problems here. Now, state enterprises, can we hold them directly responsible under international law? Well, if we look at the Articles on State Responsibility, it's subject to a number of conditions. Attribution of their act to the state. There has to be direction and control. Now, and even there, you could perhaps go as far as telling that maybe if the corporate veil of an enterprise, state-owned enterprise, is pierced, and the distinction between personality of a state and personality of a state-owned enterprise becomes blurred, the personality, the distinction becomes blurred, there you could potentially make an argument that the state does not act at arm's length in terms of management of a company and interferes in its day-to-day management. There are many examples of that in post-Soviet Union. Many examples of that, where it's a state-owned enterprise, which is the personality of which is distinct from the state, but it's managed by a state via many different means. Now, you have to establish this as a fact, but that's a different argument. As far as the private actors are concerned, now there is a lot of soft law regarding private actors' involvement in activities. Now, the question would be, are they to be held responsible under international law? I'm not quite sure. And I look at things in a very positivist light, given the school I represent, very positivist school, which is Oxford. So I look whether there is a hard law or not. The de lege ferenda does not really concern me too much. So there is soft law, but there isn't much of a hard law, and therefore holding them liable would perhaps need to go through a state, imposing on state a positive obligation, as I noted, to criminalize it or to prohibit in any other way via the domestic action. Now, again, this would require, to establish this under obligation under international law, this would require extensive analysis of the domestic practice, domestic legislation, domestic court practice. And for that, perhaps to conclude, I would make a proposal. Whoever wants to join that project of exploring that legislation, broadly speaking, feel free. I have an idea of doing it, so whoever is willing to join me or to have a joint project would be most welcome. I think there is some work to be done there. So on this positive note of joining our forces together and doing a joint project, I shall conclude my presentation. Thank you very much indeed. So I think I was in time.
Yes,
yes,
absolutely in time.